everyone, we're back. Make sure you guys check in, please. Mas passou.
Já passou? Graças a Deus. Sim, eu não sei. Só sei que ela disse isso. Fiquei, uau, vai bem. Eu não percebo nada de inglês.
Faster, people, faster. Mas ela passou.
Não, ao menos isso. Poxa, caramba. É só porque é assim, Bruno. Eu acho. Há tanta coisa aqui que tu falas que a gente na prática nunca vai usar. Para que é que a gente está a moer os miolos e tem que fazer isso um bocado, não é? Mas na escola acontece igual. A gente metade da teoria não vai usar na vida. Por que a gente tem que fazer o exame daquela porcaria? Ai.
Vamos lá começar. Começar.
24, right?
28.
Oh, yeah, it'll be.
Alright, let's see. Hey everyone, today is Ron's birthday and Josh's birthday. I guess you guys are twins? Happy birthday. Who else? Steph, I've been having problems with the student portal. Okay, send me a message on WhatsApp so we can address it, okay? After class. Thank you for joining us. Alright, by the way, Stephanie, like last week to address this, it's great. Could have addressed before. Let's see. Anything else? Can you link the chapter pages? I will. It says there that I froze. Zoom decided to play tricks on me. Sebastian says, must be Zoom, YouTube's fine. Yeah, Zoom is always the issue I have. Unbelievable. And still not working. Okay, Zoom is responding very, very slow. We are back. Mom, Dad, can you see me? I'm on TV. Can you see me? All right, we're good. All right, so YouTube was good. Zoom, as usual, playing tricks. All right, so Stephanie, I'm gonna share right now the pages. Okay, I just shared in the group. Steph, let me know if you got it. Andrea, yeah, I got your message. Don't worry about it. All right, cool. YouTubers, if anybody's there and you have any questions, you can always participate by asking in the YouTube live chat. So just let me know. All right, everybody attended. We're good. And we got real estate contracts. All right, so before we start, quick question. Did you guys have a good weekend? Yes? Studied a lot? Yes? No? No. Yeah. Okay. You guys do know that on Saturday, 10 o'clock in the morning is the school exam, right? Just want to make sure. All right, cool.
I don't have to take it now if I don't feel.
You have to.
Do I?
Yeah.
Oh, yeah? Depois de fazer as 75 horas já és obrigado a fazer o exame?
Mm-hmm.
Oh,
You have to.
as 75? Alright.
All right. Here's the reason why. Okay, so Ladiana just asked me, oh, I don't have to, if I don't want to, I don't have to take the exam this Saturday, right? If I don't want, right? And my answer is no, you have to, right? Very simply because a lot of people feel they're ready. In reality, they're not. And a lot of people feel they're not ready. And in reality, they are. So just give it a try. How much is it going to hurt? You can always take it again. So you're going to do it on Saturday. Those that are eligible to do it, they have to do it on Saturday, period. That's it. Otherwise, you're going to wait a year. Like I have a few people texting me, hey, I tried the exam in July. I want to do it again because it's almost over, the 1 year. You have 1 year to complete the course. Really? 1 year later, you reach out to me? Do you see what I'm saying? This is why I'm asking you to do it now, right? It's because life gets in the way, and now you're on the roll. Then life gets in the way, and a year later you come back, or it expires and you have to pay again, whether it's at this school or a different school. It does not matter. That's totally up to you. But I'm trying to eliminate that, okay? And you'll be surprised how many people pass the first time when they're like, I don't think I'm ready. And then they pass, right? And then there's people like, I got this for sure. Right, Sebastian? And then 30-something minutes later, didn't pass. All right.
Any questions?
He just wrote, yeah, that was me. You were too confident. You were fast and furious. That's what you were. Too fast, too furious. Yep.
How many questions? Every time is the same question. The same is the number. The number.
The number, yes.
Yes, of course it's not the same.
Well, there are some schools that even give you the exam for you to take home, do it, and come back to me whenever you're ready. Yeah, you were telling me that.
Yeah.
And that is crazy because when you get to the state exam, it doesn't help you. All right, let's start. So, okay, so New Jersey Real Estate Contracts is just 8 pages here. It's a really small chapter because, again, we're doing this as reviews. We're going to try to cover as much as we can today, 27, 28, and 29. This is only 8 pages, like I said. The next one's going to be like 17, and then the other one's like 19 pages. But most of it is reviews. Now, if we don't finish everything today, it's okay. I just want to have enough time for math tomorrow, right? And then on Wednesday, we're going to do practice exam. All right? And that's where you really get to see where you are. For me, it does not matter if you have it right or if you have it wrong. It's just for you to get a feeling of what the exam will be like. All right? So I really don't care if you have it right or if you have it wrong. Just want to make sure you're not on your cell phone texting people while you're in class or while taking the exam. Right? So make sure you take all distractions away while you're in class or while taking the exam. All right. So the Jersey Real Estate Contracts. Here's what we got. Okay. Contracts for sale. You guys already know what these are. right? It's contracts for conveyance of real estate. Lock everybody up, yeah. So preparation of contracts. If you guys remember, the only types of contracts that we can prepare are contracts on 1 to 4 family homes and lots for single vacant buildings. So lots, okay, vacant lots. That's the only types of contracts that we can prepare is pretty much for residential. We are not allowed to prepare commercial leases, option agreements, or sales contracts for commercial property, industrial property, or tracts of open land. So all we can do is prepare residential contracts. Now, does that mean that we don't get paid for dealing with commercial properties? No, of course not. It doesn't mean anything like that. We do get paid. It's just that the work is done by attorneys, not by us. We do not prepare or draft any contracts for commercial properties. Anything that's unusual, even in residential, anything that's unusual, like option agreements, for instance, attorneys prepare. We don't. Okay? We actually have what's called pre-printed forms. Pre-printed, that means all we do, guys, is fill in the blanks. The forms are ready for you. You put the name of the seller, the name of the buyer, the property address, the amounts. We don't draft anything. We fill in the blanks to the best of our ability. In fact, if you guys remember, we're not even supposed to give advice on what's written there. We fill out the contract and we say, please review this with your attorney if you have any questions. Because we are not attorneys. All right? Something to remember is that these modifications, if there's modifications to the contract, they must be initialed by the involved parties. And it is important to note that any handwritten changes overrule what is in the pre-printed form. For instance, here, let's say we're going to cross out the 5 days and we're going to put 10 days. In front of whatever we altered, we put the initials. Have to. Okay? But do we put the initials just of the buyer? No, we put the initials of the seller. Everybody must initial any change, any modification. Because it's a pre-printed form, any typed changes and any handwritten changes must be initialed always. Okay? Remember that. Delivery of the copies. So one of the things to remember, if you guys don't remember from when we talked about contracts, and we had 2 chapters on contracts, one of the things to remember is that before signing the listing agreement, sales contract, or lease is signed, the licensee must create multiple originals. That means that if we have 10 people that are part of the transaction, 10 people receive original documents for 10 original documents for their signatures. So I have to sign 10 separate contracts. You have to sign 10 separate contracts. And everybody has what's called a fresh signature in every single one of them. Okay, it's not we sign one and we give copies to everybody. No, we sign 10 originals. You got it? Okay, cool. Retention requirements. Meaning, how long do you have to keep documents? So brokers are required to handle documents as follows. We need to keep copies of unaccepted offers, purchase offers for 6 months from the date of the offer. So question, guys, how long do we have to keep the offers? How long do we have to keep the offers? Let me know in the chat real quick. How long do we have to keep the offers? Whipping, why are you yelling at me? All caps. Did I do anything wrong? Today I'm asking everybody, did I do anything wrong? Because people like treating me today like, I don't know, it's Monday. Gilbert, 5 years. Andrea M, 6 months. You said 6 months as well. 6 months. Andrea says 7 years. So I don't know where you guys saw 5 years or 7 years. I really do not know, those that said 5 and 7 years. But my question still stands. How long do we have to keep the offers? It's right there? is right there. You sure it's right there? Then read again.
Oh, the offer, you said?
I said the offers, yes.
Oh, alright, the offer accepted. 6 years.
All right, now we're getting somewhere. The answer is,
Yeah.
depends. Depends on what you were saying right now. Okay? It depends exactly on whether they were accepted or not. If it's unaccepted, we keep for 6 months. Unaccepted offers, we keep for 6 months. If it's accepted offers, they became what? Contracts. You were thinking about this? If it's a contract, you keep it for 6 years. Jose says, Rule 66, 6 months or 6 years. Okay? So, accepted offers became contracts, therefore we keep them for 6 years. If they were not accepted, in order to prevent or to prove that there was no discrimination, for instance, we have to keep it for at least 6 months. Got to remember this. Unaccepted offers. State of New Jersey says, hold on to it for the next 6 months. Accepted offers. Hold on to it for the next 6 years. Why 6 years? Because the statute of limitations in New Jersey is 6 years. Statute of limitations for what? For lawsuits. So lawsuits, statute of limitations. If something went wrong in the transaction, the buyer or the seller or the landlord or the tenant have up to 6 years to sue the counterparty, or to sue the realtor, or to sue the mortgage rep, or to sue the title company, or to sue the attorney. Anybody that would participate in the transaction could be sued up to 6 years. This is why, guys, it's so important that you keep records of everything. You remember that? Risk management. Keep records of everything. Everything you said, put it in writing. Keep records of that. All right? Very important. You went to show a house, take notes of what you saw in the house or why we didn't choose this house. All right? Very important. Keep records. That will protect you. Very important. Now, state of New Jersey, you have 6 years to sue somebody for wrongdoing in the transaction, and you have 10 years to get the property back. 10 years to get the property back. So if you want to sue somebody for compensation, 6 years. Hey, you never told me there was an oil tank, right? Obviously, you didn't do the inspection, so this is just an example. Or I was telling you the other day about the sewage backup. The seller never told me, right? So now you can sue the seller up to 6 years if you can prove that this was damage that was there before the purchase. Remember, as is has to be disclosed, right? So it's not like, hey, I didn't do the inspection, but you knew about the damage. You should have warned me, hey, there might be some damage with the plumbing. Maybe you want to check it out. Remember, disclose, 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 right? The seller might be liable for latent defects, if you guys remember. Latent or hidden defects. Things that will show up later. And they're liable, again, up to 6 years. Alini, that's no excuse. If you're listening, that's no excuse. Brenda is still late. She just sent me a message. And why isn't she already 18 years old, Alini? Giving excuses for your kid. Parents. Unbelievable. All right. Next. Brenda, when you're ready to scan and check in, let me know. I see you're walking there. Dual contracts. Who knows what a dual contract is? Yeah, your mom's fast. Brenda says, I was going to send you a message after. I didn't even know she texted you. Fast and furious. All right. So, dual contracts, what does that mean? I think the name is obvious, right? Dual contracts, that means there's two contracts, right? That's easy, but what does that mean? It means that there's two contracts for the same house, with the same seller, with the same buyer, same conditions, except for the price. So, a dual contract shows a higher purchase price so that the lender will write a loan for a higher amount. So we have the actual contract with the actual purchase price, $100,000, and then we have another contract for $150,000, which is what we're going to send the bank. State of New Jersey says that's illegal. If you sold for $100,000, then it's $100,000 you have to show everybody. If you sold for $200,000, that's $200,000 you have to show everybody. So dual contracts are against the law in New Jersey. Dual contracts are against the law in New Jersey. Be ready for that one. Against the law in New Jersey. The next thing about contracts is that there's something called plain language requirements. What is plain language? That means we all understand. So the contract, because in the state of New Jersey, you are not required to have an attorney to review the contract. It's not mandatory to have an attorney review the contract. You can do everything yourself as a seller or do everything yourself as a buyer. So state of New Jersey says, because of this, every single contract must be in plain language, common, everyday word or verbiage that we understand, right? So the use of technical terms are allowed, but there must be no confusing cross-references, longer than necessary sentences, words with uncommon meanings, double negatives, or Old English, Latin, or French phrases. Okay? So, double negatives and uncommon meanings is because when you search the law, especially the law in New Jersey, it's like redundant. It's funny. They say the same thing 3 times in one sentence, right? And one nullifies the other right away. It's very difficult to understand the laws in New Jersey. So they're saying if you're going to prepare a contract, it has to be a standard contract. It should be in plain language. Jose just wrote net selling. Net selling is something else. We're going to talk about it later, Jose. So net selling is different than dual contract. Stephanie, I'm jealous. I got to start taking my classes outdoors. Do a picnic or something. All right. You can still hear me with all that confusion around you, right? I just hear her talking to somebody out there. Just saying. All right. No fee schedule. What does this mean? It means commissions are negotiable in New Jersey. Most states have the same thing. Commissions are negotiable. That means every man or woman for himself or herself, we can negotiate the price. There's no set standards. Okay? In fact, every listing agreement must contain, as a seller, you have the right to individually reach an agreement on any fee, commission, or other valuable consideration with any broker. No fee, commission, or other valuable consideration has been affixed by any governmental authority or by any trade association or multiple listing service. So, again, state of New Jersey, you have to let everybody know that they're entitled to come up with an agreement on the prices. I charge $10,000 for this transaction. Yeah, I'm willing to pay $8,000. All right? $9,000, $8,500. Okay. Either we agree or we disagree. But we can negotiate. Oh, I charge 10%. Like, not a problem, but I'm only willing to pay 6. 7? 6.5. Sold. Negotiable. In fact, again, in every listing, we must include this statement. Not that realtors read it to them, they just fill it out and be like, oh, it's 6% is normal. Right? Just sign it and I'll fill it out later. That's 100% illegal to do. Mr. Eduardo, make sure your camera's on, please. Letter of intent. If you guys remember, I said that we cannot have contracts prepared by us for what type of properties? Commercial. So if you have a commercial property, or if you have a unique arrangement, anything that's not standard, right? What we prepare is called a letter of intent. Letter of intent says, hey, my client or my customer, depending on how you represent them, would like to purchase this property for this much. Right? That's it. If they agree, now we give it to the attorneys. Attorneys draft the contracts between them, and we're out of the picture in terms of contracts. So we prepare only a letter of intent. My client intends to. That's it. Hey, Arelis. How are you? All right. Now, real estate contract may be rescinded. Again, we're using this as reviews. May be rescinded under any of the following conditions. If there's false statements or purposeful concealment of material elements of a contract, these are grounds of rescission or cancellation. Let me write cancellation here. All right. So you can cancel the contract if there was misrepresentations. Okay. New Jersey Planned Real Estate Development Full Disclosure Act requires 7 calendar days to cancel the contract. We call this the cooling off period in New Jersey for out-of-state properties and large developments. If it's residential, we have 3 business days for attorney review. We'll go over this again in a little bit. Coffee. There's coffee, there's tea. I have a yawner here. Every 2 seconds. I'm going to turn the camera. You guys can... No, I'm just kidding. Every 2 seconds. All right. So, commercial property. Commercial property, we don't have that rescission. We have for residential 3 business days. Commercial property, like I said, attorneys prepare the contracts, and it's between them, it takes longer. Because these are standard forms, right? They have to give 3 business days to cancel. All right. Next, we have statute of frauds at the end of that page. And it says, while oral contracts to be enforceable in New Jersey, New Jersey statute of frauds requires that certain contracts be in writing. If you guys remember from contracts, any contract that's related to real estate transactions must be in writing. So if it's for the sale, of this is my Monday handwriting, okay? If it's for the sale of real estate property, transfer or conveyance of real estate property, it must be in writing. If it's about broker's commission, must be in writing, whether it's for the sale or rental. It's broker's commission, how much you're going to get paid, you must have it in writing in order to be enforceable. If it's a lease for 3 years or longer, if you guys remember when we did leases across the nation, we can have it for as low as 1 year. Well, some states, they say, hey, if the lease is longer than a year, it has to be in writing. Jersey says up to 3 years. Up to 3 years, it does not have to be in writing. 3 years or more, it must be in writing. Okay? Or contracts by lenders for loans greater than $100,000. So if you're lending $99,000, you need to have it in writing. If you're lending for $99,000, do you need to have it in writing? Gilbert, why are you shaking your head? You better have it in writing. It's your money. Right? It's definitely like, hell yeah. All right, so by law, you don't have to have it in writing, just like a release Up to 3 years doesn't have to be in writing in New Jersey. But now let's put our finger right here in our conscience and say, should I have this in writing? It's a lease. It's protection for both parties. Or it's a loan. It's protection for both parties. Because if you give me money, right, without putting it on paper, then you just gave me money. Period. You're not lending it to me. You're giving it to me. It's not on paper. We didn't sign anything. Thank you very much. Goodbye. Right? So make sure you have it in writing. Exceptions. As of 1996, New Jersey statute of frauds allows some oral agreements to be enforceable. Now, to be enforceable, we have to be able to prove that we have clear and convincing evidence. Right? What does that mean? That there was some type of information that proves your intent to transfer property to me. All right? So the only way you can do this is either by having witnesses, having something in writing that somehow shows that that's what it was leading to in terms of transfer property and transfer monies. Even if we don't have an actual contract that says, hey, we finally agree to $500,000 for this piece of land, right? Even if we don't have it in an actual contract, we can say in a message at some point, or in an email at some point, that says, hey, this is the property we're going to go see, right? Or this is my property that you're going to go see. Boom. That already shows that at one point you show the property with intent of selling. If the buyer says in a message or email or there's witnesses that the buyer said, I'm willing to give $500,000, and at some point the seller said, okay, something like that, then it starts building up evidence. These statements by themselves might not be enough. But once you pile up enough evidence, as I told you guys, keep everything in writing and keep all those records. Once you pile up evidence, then you might be able to present it in court and say, well, Your Honor, based on the sequence of events right here that we just said, $500,000 is what I agreed to pay, and he did show me this property, right? And then there's this witness, and then there's that witness, and then there's all these other messages, and I think if we put it all together, it kind of sounds like a contract to me. If the judge agrees to it, boom, you got your clear and convincing evidence that will allow you to actually keep the property. All right, and it's just funny because during lunchtime, well, right after lunchtime, one of our agents called us, my partner and I, we were just going over it, where he was saying that he is getting a listing. And we're like, oh, congratulations. Yeah, the listing is coming in about 2 weeks. I'm like, okay. Yeah, so there's this issue, and I'm like, oh, okay. What's up with the issue with the listing? All right? And he goes like, well, this is what happened. The seller was doing for sale by owner. And on the for sale by owner, a buyer showed up. Okay? The buyer showed up and they didn't put a contract together. They just did a verbal agreement. And they started moving forward. And then a month later, we're still not out of attorney review. There's nothing scheduled, no inspections yet. But because it was a vacant property, the buyer moved in. Oh yeah. I don't know if you guys remember when we had the title chapter, chapter 6, right? I know it's a long time ago, right? 22 chapters ago. But in title 6, we said that there's 3 potential buyers for one property in one example. We had somebody that was the first and moved in. We got somebody that paid the most, and we have somebody that has the deed. Remember that? So the question is, who is the owner? In this case, because the buyer moved in, the buyer has possession of the property. You want any more clear and convincing evidence than that? I'm here. You guys understand? So long story short, this scenario, the seller was able to prove that no, the contract was never in place and no monies were transferred, therefore needed to evict this person out of the property. That's why the listing is only coming another week or so because they're finalizing the eviction process. Yeah, of this potential buyer that never brought his potential money. So no potential at all in this sale. Got it? Clear and convincing evidence is key. Again, if there's commission involved, make sure you have it in writing. All right, next. The contract must be in writing between competent parties and include the description of the property, the sale purchase price, the seller's agreement to sell and the buyer's agreement to buy, the type of deed, and grantor's agreement to convey. You guys already know these by now, right? You know the type of deeds? Warranty deed? No? Quitclaim deed? Bargain and sale deed? Yeah, cool. So those are the types of deeds that we have. What about, just for the heck of it, what about description of the property? What is a legal description of the property? Do you remember this? Meets and bounds, Sebastian, good. Without checking your notes, nice. Meets and bounds, plat map, M&B, what's M&B? Plat map, and what's surveyed? That's the only thing missing. Survey, what is that? Government survey system or rectangular survey method or rectangular survey system. Yes, very good. So these are the three types of legal description. All right. For those of you that are late, I'm going to give you a quick chance. Right there, real quick. Some of you did not check in yet. Take advantage now. Rob, I don't know if you did. Brenda, take advantage. Okay. Did Brenda run away again? Check in, check in. Missing Andrea M, check in. Brenda. Mohammed's not here today. Oh. Roberto did it. Okay, cool. All right, and Brenda just did. All right, cool. All right, so the following may also be included in the contract, which would be financial contingencies, like I'll buy your house if I get approved for the mortgage, good faith deposit or earnest money deposit, evidence of title, property inspection. So, hey, we're going to inspect for any structural damages or hazardous conditions and so on. Megan's Law statement in New Jersey has to be included. Megan's Law statement. Offsite condition notice must be also included in New Jersey. Zoning, CIS, consumer receipt acknowledgement, right? And other related provisions and contingencies such as FHA, VA requirements. Now, do you guys remember what CIS is? Consumer Information Statements? Anybody? Is it the what? It's something you have to give them. Whipping, agency relationship. Yes, agency relationship. Very good. Adjusting the chair. Sorry about that. All right. Agency relationship. So this is the document that we tell everybody, hey, before you can work with me or before I can work with you, you need to be aware of the potential agency relationships, right? Who remembers what are the agency relationships we can enter into? Then, agency relationships. Buyer's agent, transaction broker, seller's agent, and there's one missing. Dual agent is illegal. Sebastian for the win. Disclosed dual agent. Stephanie, I'm getting dizzy. He's running around the house. Spinning. Disclosed dual agent. Yes, because dual agency by itself is illegal. The seller must know that you represent the buyer, and the buyer must know you represent the seller. Okay? You cannot hide it from either party because that would be a conflict of interest. You're getting paid. All right? Next, we must include a lead-based paint statement. That statement is only valid for properties that were built prior to 1978. Okay? 1978. Doesn't matter if it was renovated in 2005. The property was built before 1978. Therefore, this disclosure must be included. Okay? Only because we don't know what kind of renovation was done. Very simple. So, once we give this disclosure, the buyer has a 10-day period to inspect the property for lead-based paint. The buyer can waive that period and say, you know what? Property was completely renovated. I don't have to check for it at all. Right? I don't want to spend the extra $250 in getting inspected for lead-based paint. Right? Buyers want to save money all the time, and that's when surprises pop up. Okay? Sellers want to save money all the time, and that's when surprises pop up. Sometimes it's worth spending a little bit extra just for the peace of mind. No. Property was renovated, just renovated. I'm sure everything in the house was renovated, right? All right. YouTubers, if you have any questions, make sure you ask in the YouTube chat. There's 4 people watching. Any questions? We're using this as reviews, right? So going through everything we already covered in the previous weeks. But asking questions will definitely help. All right, notice to the buyer and seller. This is in green because it's very, very important. Every sales contract must include a notice to the buyer and seller, which provides information that should be read before signing the contract. Now, in this information, this is the cover page, by the way. The notice to the buyer and seller is the cover page. It's the first page of a contract. And in this notice, it talks about, for instance, the broker's relationship with the potential client, the seller or the buyer, right? What type of relationship do you think they can mention here in the notice to the buyer and seller? What type of relationships could be mentioned in this notice to the buyer and seller? Come on, guys. YouTubers, Zoomers. What type of relationships do you think is going to show in this page? You want a little help? Could be for both.
For one.
It's just now you're saying how you represent. Which ones?
The buyer. Agent.
The agency relationship, yes. So I already got that in the messages. Mariah, thank you. Buyer and seller agent. Right? What else? What else do you think it could be disclosed in this cover page? If it talks about being a buyer's agent or a seller's agent, it also talks about Come on. Disclosed dual agents. Yes. One more. What else could it say? You guys are making it way more complicated than it should be. There's only 4 types of relationships that we can enter into. Seller's agent, buyer's agent, disclosed dual agent, or transaction broker. We represent one or the other, or both, or neither one of them. Transaction broker. Didn't we just go over this? Which document explains these? Which document? CIS. Thank you, Sebastian. We just went over this. So how is the CIS different from this notice? How is the CIS different from this notice to the buyer and the seller? The difference is, very simply, the CIS is the first document we give that says, hey, it is my intent to represent you this way. Should you choose to continue working with me, this is what you can expect from me. Okay, so the CIS is a disclosure, it's a warning, it's a heads up, right? But this one, as we call it option 26, the notice to buyer and seller says, I now represent you this way. So the CIS is a warning. I would like to represent you this way, or I intend to represent you this way. Where this one is, I now represent you this way. You guys understand the difference? One is a wish list, the other one is I'm doing this. Simple as that. CIS is the wish list, and I'm giving you a heads up. Okay? Notice to buyer and seller is I'm now doing this, period. All right? Binding contract. So sales contracts must also contain the following statement at the top. So they must contain the following statement at the top of the first page of the contract. First page of the contract. So this is after the notice. We have the first page of the contract. And he has to clearly state that this is a legally binding contract. Legally binding contract. So what you're signing today, Mr. Buyer or Mrs. Buyer, and Mr. Seller or Mrs. Seller, what you are signing today is legally binding. But it will only become final, meaning we cannot alter anything else, after the 3rd business day. So within 3 business days, what can we do? Within 3 business days, we can review with an attorney. If I put an offer today, I'll put an offer today and I say, hey, I like your house, I want to buy your house, right? All contracts must include a 3 business day opportunity to check the terms with your attorney. Now, within the 3 business days, I can say, you know what? Pollyanna, I don't want to buy your house anymore. I'm going to walk away. Within the 3 business days, I can do that. Or, if there's something in the contract that I would like to change or dispute, my attorney has an opportunity to, within 3 business days, not after, within, initiate the attorney review clause, right? So this doesn't mean we're going to end attorney review in 3 business days. It simply means that the attorney has to say something, stand up and say, hey, oh, wait a minute. Line 101 needs to be replaced to this and that. Line 905 needs to say this or that. Commission to the broker on line whatever is only payable at the end. So these things are changes that occur during the attorney review. Can we finish the attorney review in 3 business days? Yes. Could it take a week? Yes. Could it take a month? Yes. It all depends on your attorneys. But it must be initiated. Any dispute of the contract must be initiated within 3 business days. Any dispute of the contract must be initiated within 3 business days. If we don't dispute after the 3rd business day, it becomes final. That's it. You cannot come out later and say, oh, wait a minute. I don't like what it says on line 102. Well, you should have disputed it in the first 3 business days. Now the question is, guys, when do the 3 business days start? We know when it ends. It's at the 3rd business day. The question is, when does it start? I'm sorry? When you sign the contract? Oh. Anybody? When the attorney receives it? Okay. Let's see here. The day the contract is given. Once they receive it, after the notice. Who receives the contract? I'm not understanding yet. Somebody said attorney, right? By the way, this is very important for the state exam, so you need to know. And in real life. Believe me, there's brokers that don't know when attorney review starts. It's sad. Sebastian, 3 days from initiation of a dispute. Nope. That means we can start a dispute a year from now? No. When does it start? Once the client receives the contract. Which client? Jose says, when you receive it. When I receive it? The buyer. But isn't that after the offer? Okay, no. Still something missing. When the buyer receives what? Sebastian, for the win. When both parties receive. But this is a half win because something is missing. Half win. When both parties receive. What? When both parties receive what? The contract? Nope. Well, just like Brenda said, wasn't that the offer? Right? Aha. Acknowledgement of the contract, question mark. The signature, question mark. When both parties receive the signed contract. This is key because the buyer put an offer. When he or she put an offer, it's signed by the buyer, but is it signed by the seller? No. So the agent says, hey, Sebastian, we accepted your offer. My client accepts your offer. Let your buyer know that we're moving forward. Does that start attorney review? No. Only when your buyer, Sebastian, receives a signed copy with my seller's signature, now it becomes official. See, I represent the seller. I already have Sebastian's client's signature. But does Sebastian's buyer have my seller's signature saying that yes, this is now what we're going to do, we're going to move forward? No. So don't get too excited when somebody calls you and say, hey, we accepted your offer. All right, let me see it. Give it to me. If I don't see it in my email in the next 5 minutes, I still don't count on it. You understand? So when do the 3 business days start? This is key. State exam question and real life application. It only starts when both parties receive the signed copy. No, you said receive the contract. Did you see the difference? What I said, and then in 2 seconds, what I was going to say. Okay. No, but it's not just signing it. It's not just signing it. It's me receiving a copy of the signed signature. The signed contract. I have to receive, I put an offer. I have to receive the copy of that signature. Not just a verbal agreement, hey, it's signed. I have to get it in my hands.
Both signed. Client and owner, right?
Yes.
That's it. If you don't receive, but you receive later, you sign it. So, thanks.
Only when I receive a signed copy.
Okay.
Because if I put an offer today, right, and you sign it, because I don't see you. As a buyer, I don't see you. My agent talks to your agent, right? So I don't see you, the client, the seller. So our agent's communicating and one of them says, hey, it was accepted. We're moving with your offer. Doesn't mean anything until I, the buyer, receive your your signature on it. At that point is when it starts the 3 business days. This is very important. It becomes obvious. I understand. It becomes obvious. But a lot of people account with the signature being there. It does not start until I see in my hands, that's my signature, that's your signature, we're now good to go. Until I receive that, it does not start the 3 business days. It's not a valid contract until we both have signed copies. Usually the buyer that puts the offer, unless it's a counter offer. So there's no direct order. It's just sometimes that's what people do. Like the buyer usually puts an offer, so the first one to sign is the buyer. Seller puts either another offer, accept the offer, or a counter. If it's a counter, who signed first? The seller in this case, right? Can you claim that you never received it? Absolutely. If I never received a signed copy, how can I bring it to my attorney? That's it. It does not count until we have both signatures. You, the seller, have your signed copy with my signature on it and yours, and I, the buyer, have my signature and your signature on it. I think it depends on whether or not you're lying. Really? All right, it's what I was trying to tell you. The reason why this is so important is because realtors do it all the time. They get too excited. Oh, the buyer is going to put an offer. So then you tell the seller, hey, seller, I have a buyer that's putting $1 million offer. Until it's on paper, it does not exist. Let's start with that. First thing. Second thing, hey, buyer, the seller's agent just told me that the seller's going to go with yours. Until I see it, it's not real. People, guys, you guys sometimes get excited. Oh, I closed this deal. I sold this deal. We're just in attorney review. Nothing is sold.
I don't know English, but it doesn't matter. Have the signature and the dollar. After this, you go to the bank. If the bank said you don't have credit, so nothing.
You weren't here for chapter 17. It's not after that. You should go to the bank before you start anything.
Oh, yeah?
You don't go to
you don't need the contract? Get your contract?
Well, that's to get a final decision.
Portugal, yes.
That's to get a final decision. But would you go to a restaurant without knowing if you have money in your wallet?
Of course not.
Boom. Simple as that.
But the bank just
after the bank will verify how much you qualified for. It's like, yeah, hey, I got the money in the wallet, right?
Before the contract.
Correct.
You don't
and
need
then
the contract for the bank.
No. And then once you put the contract together, once it's accepted, now they're going to verify the property itself and the value of the property and give you a final approval or a commitment to fund that transaction. All right?
Here, the bank needs contract. If I don't have contract with the buyer and the seller, I can start the
funding.
Yeah.
Well, yeah, the funding does not start, but they give you an idea if you're pre-approved. It's like a simulation. We do that in Portugal too.
Yeah.
So the pre-approval here is like the simulation there. They give you a conditional simulation, even though you don't have a property yet.
Yeah,
it's the same thing. But once you have the contract, once you have the contract itself, now you're telling the bank, hey, thank you for that simulation before. Now we're serious. Here's the house that I'm going to buy. Can you please give me a final approval on this? And that's when the final process of funding starts. So you get the preliminary, which is a simulation. And then you get to see up to how much you can afford. And then you get a final funding process. Yeah. Yeah. Brenda, what about verbal agreements? Remember, not for the purchase of real estate. If it's the transfer or sale of real estate or conveyance of real estate, it must be in writing. Jose says, in New Jersey, attorney review is not necessary but suggested. Correct. That's why we talked about plain language requirement, and that's why we have 3 business days. If you change your mind about, I was not going to use an attorney, but yeah, now I am. Well, that's why they give you what's called a cooling off period or the attorney review period, which is the 3 business days. All right, very important. We're definitely not doing 3 chapters there. Property conditional disclosure. New Jersey imposes, Lady Annie, New Jersey imposes the rule of implied warranty of habitability. So the home is being sold as warranted, fit to live in. Remember when we talked about the as is, right? As is. You cannot say as is, right? On a sale of a property without disclosing the issues. So if it's not fit to live in, if it's not habitable, I need to know the conditions of the property. If I still choose to buy it that way, as is, right, then I'm moving forward as is. But I'm aware, fully aware. And this protects the buyers from buying property with hidden defects. The seller must disclose known concealed material defects in the property, such as a leaking roof, a basement that floods, or the presence of radon or mold. Okay? All right, listing agreements. Seller's listings, buyer broker agreements, dual agency agreements, and net listing. We already covered this, didn't we? Agency relationship. You guys don't know this one by now. Seriously, right? Listing types. Different listing types. What is exclusive right to sell? Exclusive, every time you see the word exclusive, means one agency. Okay? One agency. That means only RE/MAX or only Keller Williams or only Century 21 or only New Direction Realty, for instance, can advertise this property for sale. So I have this mouse for sale. And I'm going to tell you, Susanna, you're the only one, you and your agency are the only ones that can advertise it. That's it. Open listing, I'm going to say, hey, Susanna, you and your agency, if you have a buyer for this mouse, let me know. Lady Ann, if you and your agency, if you have a buyer for this mouse, let me know. Josh, if you and your agency, if you have a buyer for this mouse, let me know. It's open. Whoever brings a buyer, it's game. If you don't bring a buyer, you don't get paid, right? But I think that's common sense to any type of agency. If you don't bring a buyer, you don't get paid regardless. The difference is, again, who is advertising? Who is committed to the transaction, right? And I did tell you that open listing was like an open relationship. There's no commitment. Therefore, Susanna, are you going to advertise my property if you know that I'm looking at with Leanna, I'm looking with Josh, I'm looking with Ron? You're going to advertise my property? No. If somebody happens to say, hey, I would like a 3-bedroom, 2-bath. Do you know of any? And Susanna goes like, I think Bruno told me about one of those. Let me call him up, see if it's still available. And that's it. You're really not hunting for people, right? But if it's an exclusive agency or exclusive right to sell, now you're the only one advertising on the MLS. And if people want to buy this property, they have to go through you, even if it's another agency. So now, Susanna, here's what's happening. Lady Anna has a buyer for this property. He has to contact you, Susanna, so you can show the property. That's the difference. In an open house, in an open listing, anybody can show the house. In exclusive, they have to contact the listing agent. Got it? What's the difference now between exclusive right to sell and exclusive agency? Exclusive right to sell, no matter who brings a buyer, the agency still gets paid. Exclusive agency, you are the only one advertising, but if I, the seller, find a buyer, I don't have to pay you. Simple. Okay? So these are the only 3 agencies that are legal in New Jersey. Jose, you mentioned net listing before. Net listing is illegal in New Jersey. We do not do net listing in New Jersey. Okay? Because net listing, right? Let me see if I have net listing here. Okay, because net listing is when we ask the seller, hey, what's the minimum that you want for this property? Right? And then we come up with our commission is anything above that value. So we are risking not working in our client's behalf. We're working on our own behalf. We just care about the money. We don't care about the client, right? All right. Yeah.
Just first one, you sell. Owner can sell and don't need pay.
Exclusive right to sell, no matter who sells, you have to get paid.
Oh,
Exclusive agency, if the owner finds a buyer, they don't have to pay you.
exclusive agency, buyer sell by yourself, you don't need your
If the seller sells by himself.
owner.
Yeah, so the
The
owner.
owner sell by yourself, don't need pay you.
So in both of these,
Okay.
in both of these right here, if I, the seller or owner of the property, right? If I find a buyer and I say, hey, Liliana, when you buy, you want to buy the property?
I have
If I find a buyer and not you,
not
you don't get paid. In this one, exclusive right to sell, if I, the owner of the property, find the buyer, you still have to get paid.
who are the buyer? Who are the owner?
I'm the owner. She's the buyer.
And you find the buyer alone.
Mhm.
Not my agent.
Not with the agent. Yes.
Agent pay me. The first and second.
No, in the second and third.
Oh my god. Okay. This is my
Look, look. The first one, exclusive rights to sell. Only you, the agency,
okay.
gets to sell.
Escrevi mal tudo.
Okay.
Ao contrário. Okay. Yes.
Only you, the agency, gets to sell. So if the seller brings a buyer, the agency still gets paid commission. Okay? No problem.
Thank you.
Every listing must include an expiration date. Every listing must include an expiration date. Guys, make sure you're always on camera, please. Gilbert just ran away. Make sure you're always on camera. Otherwise, your hours don't count. Just having a camera on don't count. You're fired, Gilbert. Fired. No, no, don't shake your head. That's it. Done. That's it. Right? Muhammad shows up like an hour later. Gilbert just disappears. Eduardo decided to take a tour of the city before coming to class. Right? Brenda goes for a vaccine. Like that's important. Right? 6 p.m. vaccine. Who schedules 6 p.m. vaccine when you have a class at 5:30? Come on. Terrible. Terrible. Stephanie gives me the tour of her house and goes outside and then comes right back in, like making us dizzy, just like. If you ever do a virtual tour like that, Stephanie, nobody's gonna buy. By the way, I actually saw one yesterday. Somebody did a video of a house. It looked like the video was having seizures. You know how there's that? You guys are laughing. You know how there's some videos where you're walking and then if it's the steps, you don't need to see steps, right? So they speed up, right? That's not a problem. You're just speeding up to get to the second floor. No. This video I saw yesterday of a house was every 2 seconds was a whoop, whoop. I'm like, whoa, hey, stop. I don't know where I'm at anymore. You're trying to make a 10-minute video into 2 seconds? I don't know where I'm at anymore. It was bad. Can you see it? I'll send you the link of that one. Anyway. Guys, you got to be conscious of your crowd. Would you watch that video if you were trying to buy a house, and would you watch your own video? Marketing, when you prepare any marketing, if you were reading it with intentions of buying, right? After reading your own marketing, would you buy it yourself? Be real. Know your clients. Know your audience. Right? Anyway. All right. Every listing requires an expiration date because a listing is a contract. It's an employment agreement. A listing is when they're hiring you to show their property. Okay? So if they hired you, it cannot be evergreen, meaning it cannot auto-renew. It has to have an end date. They hired you for 6-month listing, right? So that means as an agent, you represent the house for the next 6 months. When does it end? It has to have a specific date. So if it starts today on 4/26, it must end on 10/26, as an example, right? So 6 months later, actual date must be there. This is key. Okay, so they must have an expiration date. Especially because we have alerts at our agency, we have alerts for expiration dates. So in case you fail to sell, we're gonna knock on that door. So make sure you keep the expiration date, okay? We take over. It's a joke. I'll call you guys and let you know it's time to renew. All right, let's see. Jose, like when you go see a property and 15 minutes into the owner showing you the property, your agent decides to show up. Oh man, yeah. That is so bad. Jose just wrote, when you go see a property, 15 minutes into the owner showing you the property, the agent decides to show up. Guys, if you're not going to make it on time, let the seller know, let the buyer know. There's been times where I haven't been able to be at the showing, but to protect my client, and of course myself, I call the listing agent right away and say, hey, unfortunately, I'm not going to be able to make it. Is it okay if my client still goes by him or herself? And that's an extreme situation. Usually I try to get somebody in-house to be there for me if I cannot be there, right? Never leave your babies alone, because your clients are babies. Never leave the babies alone. Never let them cross the street alone, because it takes 2 seconds for another agent to steal them from you. Just saying. Yes. Yeah. So communication is always. You don't have to, but it's recommended that you have a good communication with your clients.
You can ask maybe you and
Another agent.
yeah.
I do it all the time.
Yeah. This is
All the time. But not all agencies are like that. So I mean, not all agents are like that. Even in-house. I'm not going to say our agency is the best in the world, right? To me, it's my agency, so definitely it's the best. And if you're working for Remax, that's the best. If you're working for Center to Win, that's the best. But camaraderie is something that's very important. We should work together, right? Because one day you're going to need me to show a property for you, right? So I'm going to call you, Suzanne. I'm going to say, hey, I cannot make. Usually we have a group chat and we tell everybody, hey, can't make it to this showing. Is there anybody available to go for me, right? And that's how you should work. Yeah. But never, ever, ever let your client go alone, unless again you pick up the phone, you call the listing agent, say, hey, it's my client that's going to show up to see the house. Is it okay? Here's the client's name. So my client, John Smith, is going to see the house. And here's my business card with that message, by the way. Right? Make it clear. Otherwise, they'll steal it from you. So avoid it at all costs. If you can have somebody else cover for you, great. If not, then at least start that contact. No problem, Andrea. Sorry, go ahead. Oh, yeah. For our phone conversation, my client is going there at this time. Here's my business card. Yep. Yep. Got it. Oh, yeah. Of course. Well,
Cliente já viu.
now you're depending on everybody being honest and not greedy.
O
Anyway,
melhor é tu estar.
the best is you being there. Yes. Oh yeah.
Oh, yeah.
Here it happens too. All right. Acknowledgement of receipts. New Jersey listings must include acknowledgements of the seller's receipt of the CIS. What is the CIS, guys? Eduardo, what is the CIS? Always disappearing, I'll tell you. What is the CIS, Eduardo? You guys cannot disappear in the school exam on Saturday, just letting you know. The moment your camera turns off, your exam terminates. Just letting you know. Okay? Consumer information statement. I know that with that. Really? What is the CIS? I know it's consumer information statement. Thank you. Dre says a wish list. Mariah, part of it is right. Part of it is right. When you wrote agency agreement, the agency part is right, agreement is wrong. Okay? For now, it's wrong. Sebastian, disclosure of agency. Okay? So CIS is the disclosure of agency. It's not an agreement because it's not a contract. It's disclosure. It's a heads up. It's a, hey, just letting you know, right? Wish list. Just letting you know that I intend to represent you this way. Okay? That's all it is. It's just a heads up, a notice. What? Before talking about financial matters, yes. It's a notification. Just letting you know that, again, I could represent you as a seller's agent, or I could represent you as a buyer's agent, or if it happens to be a listing that's mine, maybe I represent both. Or as a transaction broker, I don't represent either one. Okay, so this is important. It's in chapter 11. That's agency. Very important. You guys do not forget this stuff. Yep. And then it has to include a copy of the Attorney General Memorandum on New Jersey law against discrimination. All right. You can see the standard forms here if you guys want. Standard forms, there's links there. You guys can check it out. Okay. Net listings, I already said that it's illegal in New Jersey. We already covered it. Net listings. No. The forms are never in the exam. You just have to understand what the forms comprise of, what's involved in there, what you need to see. Like we said, the parties' names, the property description, the sales price. These are things that must be in the listing, the things that must be in the contract, and so on. All right? All right, guys, it's 7:05. We're going to take a quick 5-minute break only. 5 minutes. So 7:10, we're going to be back. YouTubers, I'm going to close this session, open another one right after. If you are subscribed, you'll get a notification. If not, just pay attention. We'll be right back.